A motion, well, I guess the beginning of proceedings before media coverage begins, I do have a request for the court regarding media coverage and the court's order before it is allowed and before it's implemented.
Okay, so you want to address that before the camera is turned on?
Yes, sir.
And with Mr. Morphew here?
Yes, sir.
All right, so I think we're ready for Mr. Morphew. I'll get my robe and enter in a moment. So I will tell you, I need to hear this request and then I'll.
I did not touch it.
Thank you all. Please be seated. Good morning to everybody that's in the courtroom, to everybody that is on the WebEx call. This is Patrick Murphy. I am the Chief Judge of the 11th Judicial District. I'm speaking to you from the district courtroom in the Chaffee County Courthouse in Salida, Colorado. We have one case on the 10th, people versus Barry Morphew. The case number is 21CR78. Mr. Morphew appears in custody with his attorneys, Ms. Rosa, Mr. Zettler, appearing in the courtroom for the people, Deputy District Attorneys, Mr. Lindsay and Mr. Pembleton.
And Stanley is on WebEx, we confirmed.
Okay, apparently also on the WebEx call is the District Attorney, Ms. Stanley. Among other things, we are here for an advisement. However, I am aware from a pre-trial or pre-hearing discussion that Mr. Zettler wanted to put something on the record regarding the recent order on expanded media coverage. So as of now, for the record, the camera that is in the courtroom is not on. Mr. Zettler?
Thank you, Judge. objection at this point and our basis for asking the court to reconsider the ruling, the order that was issued today, is based on the arguments previously made. But in addition, we are asking the court to deny the request as untimely. The procedures noted under Chapter 38, Rule 3 of the Colorado Court Rules, they do provide for expanded media coverage, but under subsection 6A, note that requests for expanded media coverage, a written request shall be submitted to the judge at least 1 day before expanded media coverage is requested to begin. And in this case, the request media coverage, at least based on the notice I received, was not received until 3:24 p.m. on May 5th, which would not be at least 1 day prior to this hearing. We would argue that the interpretation of that language to be simple due process notice issues under the U.S. and Colorado Constitution. Rule allows for an objection to be filed by any party or witness under subsection 6B with the judge objection. Given the short nature of the question being less than 1 day, counsel did not have an opportunity to file a specific written objection to the request for expanded media coverage, including the grounds for that objection and including additional orders from the court, such as allowing Mr. Morphew to appear in civilian clothes in the courtroom so that his image in jail attire and shackled would not be across the public in the face of
There's a way of doing it, but I don't know how, because Tyler just sent me a note and he's asking me to do something technical.
For those of you that are on the WebEx call, specifically somebody talking from a device named Terry, you need to mute your devices.
Yeah.
Thank you.
Nothing further, Judge. Thank you.
All right, I appreciate that argument. Mr. Zettler, let me mute this phone just a second. I appreciate your argument. Obviously, there's a number of things that we're bumping into. First of all, the requirement under Rule 5 that I get the advisement completed as soon as I reasonably can, which would be Mr. Morphew was arrested yesterday. So I wanted to get him advised as soon as possible. Therefore, there is a short period of time for expanded media requests to be made. Advisements are specifically listed under the rule as the types of hearings where expanded media coverage is allowed. Second, I believe that the defense was able to articulate, in my opinion, a very well-argued, well-reasoned, and well-researched objection prior to this hearing that is on the record. So I think the record's been made, but I will continue with the written order that I issued a half hour or so ago. So I will allow the camera to be turned on with the limitations that are in the expanded media coverage order. All right, the first thing I need to do here, Mr. Morphew, is make sure you're aware of your rights. First of all, you do have the right to remain silent, and any statement you make could be used against you. You have the right to have an attorney to represent you. While you are in custody, I could automatically appoint the public defender's office to represent you, and in fact, they have entered their appearance on your behalf. Any plea you make in this case must be voluntary. You are currently being held without bail pursuant to statute. You are being investigated for 3 charges: first-degree murder, tampering with evidence, and attempt to influence a public official. With regard to those charges, you do have the right to have a trial. That trial could be to a judge or to a jury. It would be your choice. You have a right to have that trial within 6 months of your request. At that trial, you would be presumed innocent, and it would be the burden of the prosecutor to prove the charges beyond a reasonable doubt before you could be convicted. You could testify or not at that trial. That would be solely your decision. If you decided not to testify, I would specifically instruct the jury that they could not hold that decision against you. You could question any witnesses called by the prosecution, and you could call witnesses by subpoena if necessary in your own defense. You could also appeal the outcome of the trial if you did not agree with it. You are entitled to a preliminary hearing. Mr. Morphew, did you hear and understand those rights?
Yes, sir.
Did you have any questions about them?
No, sir.
And are you affirmatively requesting that I appoint the public defender's office at this point to represent you?
Yes, sir.
All right. They have entered their appearance, so by election, I will also appoint them due to Mr. Morphew's request. All right, we've had some discussion prior to this hearing about issues to be addressed. I know one of those is a protection order. So I will ask the people, what is their request?
Judge, we met with the young ladies, the two daughters, Mr. Morphew and Ms. Morphew, and at this time, we are not asking for a protection order. We have no objection to allowing for civil contact between them at their discretion.
Okay, so are you asking that I issue a protection order but that it be civil contact?
Judge?
Okay. Any objections?
No, Your Honor.
Mr. Morphew, I will enter a protection order that will allow you to have contact with Mallory and Macy Morphew. The caveat is that that contact has to be civil, so you can't threaten, harass, or annoy. If you were to do that, and if you were in violation of that protection order, you could be charged with an additional offense. It's a Class 1 misdemeanor called violation of a protection order. Do you understand? Okay. What else from the people?
Judge, we intend on having charges filed within 10 days. And we also accept the next court date. I think the court had pre-scheduled for May 27th. We don't have anything further. Well, actually, we do have one thing further, Judge. For the record, Mr. Walker provided public defender investigator a thumb drive with the probable cause affidavit for the arrest.
Okay, pursuant to the pre-hearing discussion, the prosecution did not have an objection to releasing the affidavit for arrest to the defense. It sounds like that has been accomplished. The district attorney has ordered charges filed in this case within 10 days of today. Ms. Zettler.
Judge, those are all correct statements. We did receive a thumb drive with the probable cause affidavit for review. We do agree to that setting. Waive any further advisement of rights. We would also ask that on the next hearing date, the court be prepared to consider preliminary motions filed by the defense. We will file those in a timely manner, at least 7 days prior to that hearing.
All right, and we discussed the prosecution getting you the discovery to the extent that they can in the next 21 days. I believe we agreed on May 26th.
27th, I believe, Judge.
Okay, May 27th, that's correct. Mr. Zettler is in another hearing at 4 o'clock. Okay, then is there anything else from the prosecution?
No, sir, not from us.
Mr. Zettler.
Judge, we, of course, are expecting that the prosecution will comply with their obligations under Rule 16 in terms of their mandatory discovery obligations within 21 days. today being the advisement pertaining to discovery that is listed under subsections A1, Roman numeral 6. I'm sorry, Roman numeral 7.
Yeah, I suppose that they will do so. It's executing. Okay, then if there's nothing else, Mr. Morphew, I will see you again the afternoon of May 27th at 4 o'clock. Thank you. Court will be in recess.